Consultation should not be treated as a tick-box exercise by applicants, and interested and affected parties should not be passive participants on matters that may impact on their lives. Hi everyone, welcome to the SA Mining Desk. This is our final episode of our three-part series on consultation. In our previous episodes, we covered the legal framework and how to identify and notify the people who need to be consulted. If you're just joining us, you can find the links to parts 1 and 2 in the description below. Today, we're wrapping everything up by looking at how to handle feedback, why your participation as a community member is vital, and the serious consequences that follow when consultation is done incorrectly. Let us begin with, what is relevant information? The information provided to the public must be sufficient for them to make an informed decision pertaining to your application. This may include, but not limited to, the proposed mining activities and their associated impacts, the work programs, mining or prospecting, the environmental reports, handling comments. Every single comment, whether it's a formal letter or something said during a public meeting, must be properly recorded and considered. The applicant is legally required to include all these comments in a consultation report, which is then submitted to the DMPR. Participation by interested and affected parties. Because mining has such a huge impact, no one can afford to stay silent. It is vital that communities and landowners take part in the process. Participation of interested and affected parties ensures that identification of impacts the proposed activity may have on the area and the inhabitants. This identification allows for mitigation measures to also be incorporated within the decision of granting of rights and permits. Informs interested and affected parties of what is to be expected in future concerning the mine, i.e., blasting, dust, water, etc., and what is the plan when all mining ends. It is important to note that participation of interested and affected parties is by choice. You can choose to ignore the notices or not go to the meeting. However, if you have made that choice, you cannot say you were not consulted. What is expected from the applicants is to afford all interested and affected parties reasonable opportunities to comment on the application. If that opportunity is not utilized, it will not halt the decision-making process. The court, in the case of Salmoncore Chrome Ltd., clarified that if you, interested and affected parties, are given a fair chance to speak and you choose not to, you cannot later claim you were not consulted. Participation means that interested and affected parties engages with the information provided by the applicant, partakes in meetings, and gives comments where necessary on the documents. If the information you're given is too complex, ask for an explanation. If it's not enough, request more. Except for legally protected trade secrets, you have a right to any information, clear, simple, understandable, and that helps you make an informed decision concerning the activity proposed. Landowners and occupiers don't even need to file a formal access to information request. You can request project details directly from the department. The value of your comments. Whether your feedback is positive or negative, it needs to be on the record. As a local, you know the land better than any consultant. You might know where historic graves are located or how the project will affect your specific livelihood. When you share this knowledge, the applicant can propose better ways to protect the area and mitigate the impacts of the proposed activity. This places the department in a better position to make an informed decision concerning the application under assessment. The Register of INAPs. Every applicant must keep a formal register of everyone who participated. Make sure your name is on it. Being on the register ensures you are kept informed about the project's progress. More importantly, it ensures you are notified if an environmental authorization is issued, which is the key moment you'd need to know about if you wanted to lodge an appeal. The impact of improper consultation. If an applicant fails to consult meaningfully, the department can simply refuse the application. But even if a right is granted, it is on shaky ground. If a court finds the consultation was flawed, that mining right can be set aside entirely. In the famous Banguinyama case, the court noted that a decision cannot be fair if the person making it didn't actually see what happened during the consultation. Other consequences of poor consultation include affects the holistic identification of the impact the activity may have on INAP, which then affects developing proper mitigating measures for those impacts, resulting in community discontent on the eminent mining activities. It denies the department an opportunity to make an informed decision pertaining to the application. Long, expensive legal battles that can stop a project for years, setting aside of the decision to grant or issue mining licenses. In closing, to the applicants watching, do not treat consultation as a tick-box exercise. That is a massive mistake that could cost you your entire license. To the INAPs, participation is your power. While it's not mandatory, staying silent means losing your voice in a process that affects your life. Don't ignore the notices. Ask questions, raise your concerns no matter how small they seem. Don't be a passive participant in your own future. Key takeaways for Part 3. INAP are entitled to be given relevant information in a clear, understandable manner in order to make an informed decision about the project. Applicants must give INAP reasonable opportunities to comment on the project. Participation of INAP in the consultation process is not mandatory. They can elect not to participate, if so, cannot later say they were not consulted. INAP participation is important as it allows proper identification of impacts and development of mitigating measures. This in turn allows the DMPR to make an informed decision pertaining to an application under assessment. Lack of consultation have dire consequences of mining application or license, as it can result to refusal, legal disputes that delays projects, and setting aside of issued rights. Thank you so much for joining us for this series. I truly appreciate all the likes, comments, and messages. If this was helpful, please hit that subscribe button. Until next time, take care.